alleges that in October of 2021, Mayor Cantrell and Jeffrey Vappy, a member of her executive protection team, developed a personal, intimate relationship. From that time until Mr. Vappy's retirement in June of 2024, they embarked on a scheme to defraud the City of New Orleans and the New Orleans Police Department. By exploiting Vappy's job and Cantrell's authority as mayor to have the city and the New Orleans Police Department pay Vappy's salary and expenses during the times that Vappy claimed to be on duty, but when he was actually engaged in personal activities, usually with Ms. Cantrell, but sometimes alone at the Pontalba apartment. The indictment further describes the many steps that Cantrell and Vappy took to hide their scheme and to perpetuate their continued fraud, including using a secure messaging platform, WhatsApp. Specifically, Cantrell and Vappy used the WhatsApp platform to exchange over 15,000 messages, pictures, and audio clips in an 8-month period. They also used WhatsApp to intimidate subordinates, to harass a citizen, to lie to colleagues and associates, to delete evidence, to make false statements to FBI agents, to give the government an affidavit signed under oath that contained numerous false statements, and ultimately to commit perjury before a federal grand jury, all for the purpose of distracting and impeding inquiries and investigations into their activities, including a federal grand jury investigation. The superseding indictment, which we emphasize is merely a charge for which guilt must be proven beyond a reasonable doubt in a court of law, alleges that Mayor Cantrell and Mr. Vappy perpetuated their scheme both in the New Orleans area and during out-of-state trips. In both instances, Vappy's activities, while claiming to be on duty, were conspicuously different than any other member of the Executive Protection Unit. While in New Orleans, Cantrell and Vappy treated a city-owned apartment in the Pontalba building as their own personal shared residence and coordinated to spend time together there, engaging in personal activities, all while Vappy claimed to be on duty for the Executive Protection Unit and was being paid to do his actual job. The superseding indictment also alleges that Mayor Cantrell and Vappy arranged for Vappy to accompany Cantrell on at least 14 domestic and international trips to maximize their time together and to engage in personal activities. In their private text messages, Mayor Cantrell characterized her trips with Vappy as both, quote, times when we are truly alone, close quote, and as what, quote, spoils me the most. These trips included a trip to San Francisco, which Vappy and Cantrell decided to extend for an extra day so that they could visit a series of Napa Valley wineries. While Vappy was wine tasting on April the 9th, 2022, he claimed to be working and was in fact paid for working a 15-hour day. In August 2022, Cantrell said that she would, quote, unquote, make it happen, to have Vappy accompany her on a 3-day trip to Washington, D.C. for a 1-hour meeting, a trip that they both agreed they, quote unquote, needed. Shortly after they returned, Vappy described the trip to Cantrell as, quote, another leg on our journey, close quote, as he declared his love for her and their physical relationship. In total, the city of New Orleans paid over $70,000 for Vappy's travel on these trips alone. When asked about her reason for bringing members of the Executive Protection Unit with her on out-of-state trips, a practice that Mayor Cantrell began about 5 months after Vappy joined the Executive Protection Unit, she justified it as a quote-unquote pivot due to COVID and a matter of safety, in quotes. At the same time, however, she continued to take out-of-state trips without any EPU protection or Executive Protective Unit protection. In fact, on the same day, she gave one such statement. She canceled a work trip to Miami and instead traveled alone by plane, then bus, then ferry to the island of Martha's Vineyard in Massachusetts to spend some time with Vappy. Vappy was in Martha's Vineyard attending a conference paid for by the city of New Orleans related to his position on the Hanno Board of Commissioners, a position to which Cantrell had appointed him just months earlier. On other occasions, when Vappy was unavailable to accompany Cantrell on a trip, Cantrell chose not to take another member of the Executive Protection Unit with her. The superseding indictment alleges that both Vappy and Cantrell were aware that their conduct broke laws, criminal laws. For instance, in April 2022, an associate of Cantrell's explicitly told her in multiple text messages that spending public funds and using public resources for her personal relationship was illegal. When Vappy and Cantrell learned that the news media was investigating their time together in the Pentalba, they agreed amongst themselves to be, quote, unquote, straight and together. Days after the first news stories broke in November of 2022, Vappy conducted numerous online searches for New Orleans area attorneys who specialize in the practice of criminal law. And he researched WhatsApp's security features. But the defendant's wire fraud scheme nevertheless continued all the way until Vappy's retirement in June of 2024. As alleged in the superseding indictment, in July 2023, the grand jury issued subpoenas to both Vappy and Cantrell, compelling the production of records. The FBI also interviewed Vappy, and during the interview, Vappy lied about the nature and circumstances of his relationship with Cantrell. In response to the subpoena, Cantrell produced a selection of responsive records, but none of the over 15,000 WhatsApp messages that she had exchanged with Vappy. Cantrell also created an affidavit, sworn under oath, that in 2021 she had activated a feature on her phone that automatically deleted messages. In support of that statement, in her affidavit, Cantrell submitted a screenshot of her iPhone showing WhatsApp messages were set to delete in 24 hours. But in fact, Cantrell did not turn on that feature until December the 26th, 2022, roughly 1 month after the news media began speculating on her conduct. Moreover, this automatic deletion or quote-unquote disappearing messages feature only applied to new messages. During roughly the same period, Cantrell also manually deleted thousands of her prior WhatsApp messages with Vappy. As alleged, even at the time that Cantrell responded to the grand jury subpoena, she still possessed more than 50 pictures, including screenshots of correspondence with Vappy that were responsive to the subpoena, but which she nevertheless concealed from the grand jury. On his own, Vappy conducted online searches concerning WhatsApp and its security level, and by which time several people had already warned Vappy and Cantrell that their conduct was illegal. The indictment further alleges that Vappy and Cantrell continued their pattern of obstruction through the rest of 2023 and 2024. This obstruction included improperly pressuring the interim superintendent of the New Orleans Police Department to overrule findings of an internal investigation into Vappy's conduct. When the interim superintendent did not heed that directive, Cantrell ordered the interim superintendent to nevertheless reassign Vappy back to her protection detail. Months later, in a meeting that Vappy attended, Mayor Cantrell informed the interim superintendent that the interim superintendent would be replaced. Similarly, when a private citizen took pictures of Mayor Cantrell and Vappy together in public, dining and consuming alcohol al fresco, while Vappy reported to be on duty, Cantrell filed a police report and sought a restraining order against that citizen. This indictment does not allege that a relationship constitutes a crime. It also does not allege that the criminal activity occurred on merely a handful of discrete days or that the behavior was limited to a small series of discrete actions. Rather, it reflects the prosecution of two public officials alleged to have engaged in a years-long continuing fraud scheme that used public money for personal ends by exploiting their power and their authority. The superseding indictment alleges that they perpetuated that fraud scheme by taking steps to keep individuals silent, to deceive subordinates, and to obstruct investigations into their relationship, including one conducted by a federal grand jury. I'd like to make several things clear, if I may. First, my office remains steadfast in its commitment to rooting out public corruption in any form without fear or favor within the Eastern District of Louisiana. And by the term public corruption, I mean public officials exploiting their positions and their power for their own personal gain. Public officials should be in their jobs to serve the public and not themselves. To do otherwise is a breach of the trust that undermines the public's faith and trust in their own government. Second, this investigation remains ongoing, and I would encourage anyone with information to come forward and to do so quickly. They can do so by contacting the FBI at 1-800-CALL-FBI or at fbi.gov, submit a tip. As I close today, I wish to emphasize that our investigations and our prosecutions go wherever the evidence takes us. Today's superseding indictment is the culmination of a lengthy and a deliberate investigative process in the ultimate pursuit of justice. No decision in this case was made lightly. I'd like to recognize the dedication at this time of the career prosecutors handling the case. To my right, Supervisory Assistant U.S. Attorney Jordan Ginsburg, who is Chief of the Public Corruption Unit, and AUSA Assistant U.S. Attorney Nicholas D. Moses of the Financial Crimes Unit and our Healthcare Fraud Coordinator. These men were ably assisted by numerous staff members of our office who dedicated their time and energy to assist them. I also specifically recognize the supervision of Tracy Knight, who is our criminal chief and has done a wonderful job in supervising this investigation and this prosecution. Individually and collectively, I am proud of this office's collaborative, professional, selfless, and unrelenting efforts. But such a case as this requires really tremendous partnership, and we have been blessed to have such. I want to thank the members of the Federal Bureau of Investigation's New Orleans Field Office, led by Special Agent in Charge Jonathan Tapp, and his team members, Assistant Special Agent in Charge Percy Giles, and also ably assisted by Supervisory Special Agent Samira Maroney. The FBI spearheaded this investigation and have been with us on this matter from day one. The tireless work of FBI's agents, analysts, and support personnel deserves very special credit. I'd also like to recognize the indispensable contributions made by the Cybercrime Lab of the Department of Justice's Computer Crimes and Intellectual Property section. Finally, I'd like to thank and recognize the New Orleans Office of Inspector General and the Metropolitan Crime Commission for their great cooperation in this case and their dedication to identifying and reporting corrupt and unethical activity by public officials. I'd now like to invite up to the podium to say a few words FBI Special Agent in charge of the New Orleans Field Office, Jonathan Tapp.
Thanks, sir.
Yes, sir.
Thank you, Mr. Simpson. Good afternoon. I'm Jonathan Tapp, Special Agent in charge of the FBI here in New Orleans. Unchecked public corruption undermines the roots of our great republic. The citizens of this nation expect their public officials to uphold the public's trust, and the FBI investigates breaches of that trust that constitute violations of federal law. The citizens of New Orleans work hard to provide for their families, and they expect their public officials to be honest stewards of those funds. And today's indictment outlines a betrayal of that trust by Mayor Cantrell and Mr. Vappy. The FBI has a duty and obligation to investigate and work with the U.S. Attorney's Office and our partners to hold individuals accountable who put their interests ahead of those they've sworn to serve. No one is above the law. The charges outlined today are very serious, and they emphasize the importance of accountability. Today's superseding indictment is the result of painstaking work by FBI special agents, forensic accountants, and analysts who investigated every lead and piece of evidence discovered in this case. A strong criminal case is built on facts, and the investigative process to uncover those facts, can take days or even years. But the FBI is committed to the people of New Orleans and Louisiana to methodically address every element of an investigation, and that's exactly what we did here. The indictment speaks for itself. It outlines just some of the information uncovered in our investigation. The full scope of the investigation will become available through the adjudicatory process. I want to thank the Department of Justice, the U.S. Attorney's Office for the Eastern District of Louisiana, and especially the Computer Crimes and Intellectual Property section, Cybercrime Lab, and its critical assistance here. I also want to thank the Metropolitan Crime Commission in particular for its help along the way. We appreciate the public's interest in this case and encourage anyone with information about this case or other violations of the public's trust to call the FBI. We can't do this job alone. With the help of the public and our partners, we'll continue to carry out our mission of protecting the people of Louisiana and the United States. Thank you.
So everyone, I guess this is the time for you all to do your work. We have time for some questions. Of course, I listened to my manager right there, Shane Jones. So, but please feel free to ask away, and forgive me if I drink water during the process. Yes, sir.
David Hammer, WWL. Did you take pause at all about bringing criminal charges that at the heart are based on a romantic relationship, especially with the first woman mayor of the city of New Orleans?
To me, it's irrelevant that it's romance or that it's female. What is relevant is that it is an incredible breach of the public trust it's an incredible betrayal of people's confidence in their own government, and it's a violation of innumerable federal criminal laws. That's what's important to me as a prosecutor. My job is to participate in the investigation and prosecution of federal law. Who breaks federal law and their particular characteristics is really irrelevant to what we do. We follow the evidence, we follow the law wherever it leads, and we do our jobs.
Mr.
Cass.
Can you please speak to the Gabriella Proxy? Thank you. Can you speak to some of the challenges in prosecuting this case, as there's been denial after denial, of course, related to also having false statements in front of the grand jury, and then also if you can speak to it all whether the grand jury has been released from subpoena, if they're going to continue to sit and hear more aspects of this case at all, or if there is any other grand jury proceedings pending.
Well, I can't comment on the grand jury because of, obviously, very strict grand jury secrecy rules and regulations. What I can say is that the investigation in this matter is decidedly ongoing. And whatever leads, whatever information we get that is actionable, that we can develop into evidence that indicates additional federal crimes or individual players in any or all of this, we will pursue.
Cassie
Part
Sherman.
of my question about how, the challenges of just, of constantly, in your own words, making false statements in front of the grand jury. I mean, what are the challenges to be constantly kind of reiterated by the mayor that the allegations are false?
What are the consequences? The consequences are criminal. And when they become criminal, when the falsity of those statements is established by evidence that proves their falsity, that's the consequences. And people can say what they want, clearly in their own defense, and the mayor is absolutely correct in exercising her right to do so. What I would say is the ultimate judge of all of this is the evidence that we have developed that forms the basis of this superseding indictment.
Cassie Sherman with WDSU. So in the documents, it alleges other people knew about these actions. Could there be any more indictments further past this from public officials?
Well, I can't answer that right now because, as I indicated, our investigation continues. So the possibilities are open. We don't know. I can't predict one way or another, and I'd be inaccurate if I said I had any sense of that. But I assure you, when I said that this is still a vital and ongoing and active investigation, it is.
The people that you guys were seeing the text messages that were warning the mayor, did you guys talk to them in person or have an interview?
I think the reason why we have evidence is because it is supported by reality. So I won't comment on specifically the evidence, but one thing I've learned as a federal prosecutor over a long time is that you really don't say anything unless you can back it up pretty definitively.
And then my last question, just real quick. In the past, the mayor has said these allegations have been politically motivated. What would you say back to that?
I'd say that's a nice defense. That's a defense that you would use in court.
The dates of the charges go back to 2024, or go as late as 2024. Why not wait until she's out of office in just a few months? And are you concerned about how having a mayor under indictment will affect the administration of the city of New Orleans?
Yeah, again, my mandate as a prosecutor really deals with when the evidence and the facts and the circumstances reach a point of rightness so that a prosecution is mandated, we act. I don't think in terms of the political calculus, particularly because that's not my job, that is for someone else. But the excellent prosecutors and the law enforcement partners that we have, our jobs are very different. We go after lawbreakers, and especially in this city, public corruption has crippled us for years and years, and This is extremely significant to act when the evidence demands it, and that's what we're doing.
Mr. Simpson, James Finn, speaking in.
This is the last question.
Okay, the administration at the bureau level and at the level of the Justice Department is pretty demonstrably refocused away from public corruption investigations. Did that have an effect on this investigation, and did it present any challenges?
I don't, in our office, the reality is that whatever cases we have, if we have sufficient evidence, be it public corruption, be it violent crime, be it financial crimes, we do it. Whether there is an initiative by a particular administration one way or another, it doesn't make any difference. If we have a crime that we can prove of any sort that is a violation of federal criminal law, that's what we do. We investigate it, we build a case, and when it comes to the point where we feel like we have proof beyond a reasonable doubt of each and every count that is alleged or crime that is alleged within that indictment, then we do our jobs and we prosecute it.
Mr. Simpson, what's the timeline for next steps?
The timeline for next step would be really the timeline. Are you talking about proceeding to court?
I mean, eventually, you've got some, you've got a couple, what's your next interaction with Mayor Cantrell? And eventually get into court, what's your timeline there?
Well, apparently the next step would be an arraignment for her. And there's, of course, a bond procedure. And from there, it proceeds as any other federal criminal case would go. There are a plea of clearly not guilty would be entered, as they always are. And then trial dates would be set. Discovery would occur, which is obviously the exchange of documentation and information between the government and the defense and vice versa. And then it goes from there to however it resolves, be it in a courtroom, at trial, or whatever else the options are, a plea or what. And there will be motions, legal motions filed continuously during this process, of course, to shape the direction of the case.
Okay, thank you, everyone. Thank you, everyone. Thank you.
Quick clarification, on the text messages, you mentioned that many of them had been deleted. Are the ones within the indictment, were they deleted, or were these simply the ones you were able to recover, and there's some that you were not able to recover?
I think when you read the indictment and get a chance to really study it, it'll answer that question for you.
Thank you, everyone. Thank you, everyone.
Thanks. Appreciate it. Thanks, all of you.
All right, you just saw Michael Simpson and the FBI Special Agent in Charge, Jonathan Tapp, laying out the details even more than what we saw in the indictment so far. I think the line that stuck out with me as we're joined again with Pat Fanning, Dr. Ed Shervinack, Dr. Silas Lee, he said, we go after the law breakers. If you could just talk about that, because he says we don't get into the political calculus, we just go where the laws are broken.
Later justice is blind.
Yeah.
Right. You know, that any hint or whiff of impropriety is going to be looked at by the U.S. Attorney's Office. And so they're not thinking in terms of politics, even though it's a political exercise. But they believe that this corruption is a breach of trust, a betrayal of trust, and that citizens, taxpayers should not be ripped off by their political leaders.
Basically, what he's saying is that it's a marriage. Citizens, elected officials, when somebody violates that marriage, they must be held accountable. And regardless of race, gender, we are going to pursue accountability in that arena. And that's what you saw here. Now, yes, she is the first female mayor, first African-American female mayor, and a lot of people are concerned about that, given the circumstances and events around it. But bottom line, he says that we are looking at the pursuit of justice.
irrespective of whether or not this was bribes or kickbacks, even though this involves a romantic relationship. He said we didn't take that into account as much as, he said about their scheme. They said two public officials who perpetuated a fraud and a scheme for years on taxpayer dollars is what his exact
And the
words.
key word, public officials using their positions of authority, influence to navigate and negotiate activities that were not sanctioned for their own benefit. And that's what we see as the heart of this to a large degree.
Legally, does this change anything? And look, we always ask for your opinion, and I go back to this, and I know that we've said it a couple of times today, but you do have great context, Pat, and historical understanding, having dealt with former Governor Edwin Edwards representing him. Does anything change from a criminal defense standpoint from what you saw just now?
No, and when he says things like, we go after lawbreakers, if he says that in a courtroom and I'm on the other side, I'm going to say, no, they go after who, in their opinion, they consider to be lawbreakers. Ladies and gentlemen, the jury, you'll decide whether a crime was committed. So he can make those self-serving statements when nobody's there to call him on it. But, that's just the way it always goes. What I did notice that I thought was a good thing for him to do, he emphasized to me more that they violated the public trust by having $70,000 in trips for this guy of taxpayer funds that were for personal vacations and not for business purposes or city purposes. And he didn't seem to take too much time emphasizing, and he never used the term that they had a sexual affair. And so I think, he's going to go in and say, look, ladies and gentlemen, it's your money that they blew doing what they were doing. And even whether they were having sex or not, they're going to Napa Valley to go to vineyards to go drink wine on the public money. That's wrong, and you ought to find them guilty of that.
Let me ask you, go ahead, Gina.
I was just going to say, he also he says, while claiming to be on duty, Officer Vappy, who had different responsibilities from other members of the Executive Protection Unit, that they used the Pentalba apartment as their personal shared residence as well. So that also goes into, taxpayer dollars and making the case on public corruption.
Use of their position, as well as how people feel about that. It would be interesting to go through the jury selection process. Some of the questions, after going through that and observing the questions I've done in other cases, is always interesting. And you can imagine one of the first questions, you ever had an affair? Kick them out. But it's going to be very interesting, the jury selection.
It'll be a year to get a jury.
That's right. That's the problem.
Let me ask you all this, too, and we get the politics of it and the legalese of it, because it's a question that people watching right now, we all watch a lot of social media. We all are on our phones and our devices, and we see the X and Facebook and Instagram. But the mayor made comments about a month ago in Tampa saying that she felt like she was being targeted. Is the defense going to be that the Trump administration and that the U.S. attorney is going after a black female mayor? But mind you, this all started during the Biden administration, but legally, if you've only we'll have everybody's opinion on that one.
Well, that would be the kind of thing that would be ferreted out in pretrial motions. If the government thinks that she's going to go in there through her attorneys and say, I'm the victim of a political vendetta, then the government files a motion in limine and say, no, Judge, that has nothing to do with this. Did they take $70,000 in public funds and go on private vacations with it? That has nothing to do with Donald Trump, and they should not be allowed to bring that up. So that ought to be decided before you get before the jury. But that may well be a part of the defense. I mean, we call it overreaching. You went after this for some reason other than just the fact that the $70,000 crime was committed.
Politically, is that something that we could hear on the political side of this?
Absolutely. That's going to be her message, is that this is a witch hunt, that she's been targeted because of who she is, not what she did. And with the effort to influence the jury pool, that she wants to get people on that jury pool who will be sympathetic to that point of view, that she is a target and that this is just being made up and that it's not as bad as it looks. And so, I'm a target. This is a witch hunt. That's what we're going to be hearing out of her defense, I'm sure.
You know what else, Travis? They may try to pursue a change of venue, which a big stretch, but I've had to do polls for change of venues, and it wasn't changed. But I can see that as one tool they may try to introduce
I mean, Nagin was handled here, but I mean, Bill
Yes.
Jefferson, I remember there was a big
his
thing with the
brother.
venue with Bill Jefferson because it wasn't done in New Orleans, it was done in Northern Virginia. But I mean, is that difficult to change the venue for a case? or
Yeah,
something
judges
like
don't like to do that, and, you know, you have to prove that you'd be prejudiced. When I represented Len Davis, who
Right.
Silas was involved in, he had already been convicted of and given the death penalty, and then I said, like, he was on an A&E special about police corruption. I said, you got to get him out of New Orleans. Judge Feldman said, oh, no, the jurors, they'll be fair, don't worry about it. So if he couldn't get it after that, then I don't know how this lady, but that might be a motion that's filed. But what she's going to have to ask herself, Carlos Marcello was picked up on a wiretap in Brylab, and he famously said, you know, if I ever get indicted in New Orleans, I don't want any change of venue. I want to stay right here. People love me here.
Yeah.
She might
Right,
think
that
she
was
only
it.
needs one juror from here to help her.
All right. We are going to get to Jonah Gilmore. He's standing by with a live interview, I believe, with Raphael Gorinetti with the Metropolitan Crime Commission.
Yeah, Travis, Gina, we are here with Raphael Gorinetti with the Metropolitan Crime Commission. Obviously, an historic day here in the city of New Orleans. A city mayor indicted on federal charges. I know this is an unprecedented event. A lot of waves around the city, a lot of reactions around the city. But we're going to be speaking with Raphael Gorinetti right now. We're going to get ready to talk with him. And we have Metropolitan Crime Commission here right now.
To this indictment.
Mr. Gorinetti, obviously, 14 charges right now. Honestly, you turned over federal documents to the federal government. Did you think it would be this many charges?
I thought that there would be charges. I had no idea how many, because the information that the Crime Commission turned over to the government beginning in 2022 was the beginning of what we as private citizens had uncovered. I had no idea what the FBI and their partner, the United States Attorney's Office, had developed independently. So what our standard operating procedure is, if we get information about wrongdoing, we're going to refer it to the appropriate agency. The appropriate agency to investigate the information that we received, we concluded, was the FBI. We made that referral in 2022. And once we make that handoff, we're out of it until they acknowledge our role and assistance. So we provided a number of tips, a lot of detailed information about the mayor and Officer Vappy, as well as some other things as well that haven't been discussed today. And today we saw the superseding indictment issued involving 18 counts of criminal wrongdoing on the part of Mayor Cantrell and former Officer Jeffrey Vappy.
What should the citizens of New Orleans take away from this indictment?
That if they report something that's wrongdoing, something can and will be done about it. So we're seeing the mayor of the city of New Orleans and a former police officer that are accused of a variety of federal felony offenses being held accountable. So I think every one of these cases that are wrongdoing, corruption, the offenders don't do it in broad daylight while in front of an FBI agent. So that makes it critically important for the public that has information that documents the wrongdoing to step forward and provide that information. In this particular case, at least some of the evidence that was released today and acknowledged in the indictment started with citizen tips that provided the information, the documentation, photographs, and other relevant information that we in turn made the handoff to the FBI years ago.
And when you look at the charges, we're talking about wire fraud, obstruction of justice, and lying to the grand jury. These are some pretty serious accusations.
Oh, absolutely. I mean, every one of these charges are federal felonies. So potentially, both Mr. Vappy and the mayor are facing potential time in a federal penitentiary if they're convicted. So today was the beginning. It was the indictment phase. And as is mentioned in every government press conference, these are just accusations. There's a presumption of innocence, and it's going to be incumbent upon the government to prove beyond a reasonable doubt they are in fact guilty of these offenses.
Can you talk a little bit about, of course, over the past year or so, there were rumblings that, oh, the mayor might be indicted now, and then it didn't happen. And here we are a year later, it came down today.
Well, I mean, so we saw the first indication in October of last year when Officer Vappy was indicted. And in his indictment, it was referenced Public Official 1 in email communications and text messages between Officer Vappy and Public Official 1. And that was the first confirmation that the Officer Vappy, was charged with a series, I believe, of 7 felony violations with respect to wire fraud, and that Public Official 1 was involved in that. So today we saw the official superseding indictment naming Public Official 1 as Mayor Cantrell, and she is charged with 11 counts of federal felonies in relation to the investigation and indictment that we first saw last October when Officer Vappy was indicted.
Is there anything in the indictment that stands out to you or shocked you, if you will?
So
our investigative reporter, he talked to Jordan Ginsburg shortly after the indictments were handed up and was told that it was multiple counts. We're still waiting to get the indictments in our hand, but is there any surprise there? What can we read into that little bit of information?
No surprise there. I mean, you're rarely going to have an actual indictment where it's going to be, confined to just one particular count. You'd see that in maybe a guilty plea, where, there's some agreement beforehand where there's a factual basis, a plea agreement, and a bill of information. But an indictment that's going to be contested, you would expect to see multiple counts.
Have there been any discussions, do you think, between the assistant U.S. attorneys involved in this case and Cantrell's attorneys? Or would any negotiations have begun, or is there any kind of interaction up to this point?
That's always possible, and of course, you never know. Only those particular parties know. You would typically have at least the issuance of a target letter, where obviously if you have a putative defendant, the Department of Justice manual dictates and mandates that you go ahead and issue a target letter and invite that particular putative defendant to the grand jury if they would wish to attend. That would probably have happened here, and likely Ms. Cantrell would have declined that particular offer. There potentially could have been some settlement negotiations, plea negotiations, but you really don't know at this point.
Once that letter is issued, would that make a would-be defendant sort of reticent to give any comments whatsoever about anything having to do with the legal ramifications of what she might say? And could that be a reason why we've seen so few news conferences from her in recent months?
Yes, 100%. I mean, that's going to be super rare, not unheard of, but super rare for a particular putative defendant to go ahead and take that invitation and to actually present testimony to the grand jury. One, at that point, the indictment, is probably in the works anyway, and you're only going to do yourself damage by presenting some testimony that you're really not exactly sure of the context of how it's going to be. You can't control it. Your lawyer's not in there with you in the grand jury room, so it's very unlikely that that particular episode occurred.
Is a case like this being handled strictly out of this U.S. Attorney's Office, or is there a public corruption unit out of Washington, D.C. that could be involved in this prosecution?
There is a public corruption unit. It's called PIN, Public Integrity, but as of yet, you haven't seen any of those individuals sign any prior indictments of Mr. Vappy or Mr. Farrell. So I believe, at least at this point, it's going to be just on the U.S. Attorney's Office here in the Eastern District.
I know they were active in years past, been very active in Louisiana in years past. It doesn't seem like we see as much out of them as we used to. At what level, when do they decide to get involved?
They'll typically be involved when the local U.S. Attorney's Office may recuse itself for having some conflict of interest. Public integrity will usually step in at that point. Or sometimes they can also have their own investigation in cases that they prosecute out of Washington, D.C. But if a local U.S. Attorney's Office takes that case, there's no particular reason for public integrity to be involved.
Matt, what is it like to prosecute a popular figure like a mayor, someone who's been elected twice by a majority of voters in a parish? How do you wipe that out of your mind to go about, as a prosecutor, to go about the business that you must tend to?
You certainly have to follow the normal, traditional, standard approach to any type of investigation prosecution. You know, to uncover probable cause and sufficient evidence to prove beyond a reasonable doubt that a particular individual committed a particular specific violation of a federal criminal statute. You can't start chasing headlines. You can't chase a particular individual, nor shy away from doing that just because they're an elected official.
One way of quantifying the amount of man hours that go into a case like this by the attorneys involved and by federal investigators?
Countless at that point. They're there. They're probably, it's not the only case they're actively pursuing, but it's going to be one of the few, given the ramifications, given the scope, and given what's at stake.
Could you share with us what goes into the actual charges that will be brought by a grand jury? What is it's not the same burden of proof as a criminal trial, but there has to be a pretty high standard to include certain charges in an indictment. Can you walk us through how that process works a little bit?
Sure. The grand jury finds probable cause, and that's it. That's their standard. That's the level of proof that's required to be presented to them, and that's what they'll return, and that's what apparently happened this morning, this afternoon, I should say. And then obviously at the trial level, it's going to be up to a jury. All 12 must decide on a legal verdict, and that's going to have to be guilty or not guilty, and that's got to be beyond a reasonable doubt. So two different standards at play.
Did you handle the naked grand jury?
No comment.
Can you say whether you've handled grand juries before?
100%. Every assistant U.S. attorney handles all grand jury matters. It's a vertical prosecution where the cases are taken from the investigation stage all the way through trial and then appeal.
So a grand jury that's been meeting as long as this one has, we believe over a year, do they get invested? I know you don't want anybody's personal grievances to get involved in this, and they're all vetted to make sure that they could act objectively correct. But in terms of just doing the job, is there kind of a will to want to see it through to some conclusion, or does it just depend?
It just depends. The grand jurors that are impaneled have traditionally have had no issues with recusals or conflicts. If there's an issue where a particular grand jury would happen to know a witness, they can raise that to the assistant U.S. attorney and or the district judge. That person can then remove themselves, and the other grand jurors can take the case itself. As you said before, the grand jury is a body of at least 16 voting, or at least voting, and then 12 to actually pass an indictment, but you can have as many as 23. So that flexibility in those numbers allows for people to recuse themselves, step out the room, and the other grand jurors can take the case from there.
You've handled both kinds of juries. Do nerves get as frayed as they would in a normal criminal trial, or is it more relaxed than that?
Criminal trials are a beast of themselves, and especially when there's media attention, and given the stakes, that's going to be different. The grand jury is a formal, recognized process, but the outcome is not as much in play as it would be in a jury trial, because of the standard is so different.
Are there different standards involved in deciding whether to bring a bill of information against a defendant or to try and get an indictment?
Correct. A putative defendant has to agree to a bill of information for a felony. So that has to be by agreement to proceed in that fashion. And that's 95% of the time standard when someone is pleading guilty and there's been some pre-charging agreement between the defendant and the government. But if there's been no agreement, that's going to proceed by indictment, not by bill of information.
Would that happen with somebody who's been given a target letter, or would that normally happen with somebody who may be cooperating with the prosecution?
Bill of information is going to be someone who's cooperating with the prosecution, 100%. And that person may or may not have received a target letter themselves, typically not. Typically the target letter is for that putative defendant that has already expressed almost no interest in pleading guilty prior to some indictment. So you typically see two paths. You're going to see a bill of information without a target letter. You're going to see an indictment with a target letter that the public doesn't know about, but the defendant receives, and then the indictment, and then eventually a trial or a guilty plea, because those are the only two options.
Most of the people we've seen involved in this case were, prior to today, it is assumed that she was mentioned as public official A, have been indicted. I don't know if we've seen too many bills of information in this case. Correct me if I'm wrong. Can we read anything into that?
No, because some may be sealed. So you never know what goes on behind closed doors as far as that's concerned, or some that may be filed between now and some trial date. So you just never know exactly what the timing would be. There was something that you could read into from last year's indictments, obviously, that she was identified and referenced as public official A, which would typically mean that she's going to be indicted. It's taken some time, but it's led to this date nonetheless. But as far as others, you just have to wait to see.
Would you be surprised to see some bills of information unsealed in this case?
Not necessarily.
How important, there's been a number of phone calls that were brought in the VAPI investigation. What do we know about the surveillance that was used so far in some of these previous indictments, and what sort of evidence do you think, can we speculate as to what sort of evidence might be presented when this case is brought to trial? Is there a standard of evidence that must be met, and is electronic surveillance techniques part of that standard these days?
It's typically part of that standard or what you see out there, but in historical public corruption cases, it's less prevalent. If you're talking about a narcotics investigation, you're going to see consensual recordings, wiretaps. In the Edward Edwards case, for instance, there was long-running wiretaps on multiple phones, multiple targets themselves. But in historical public corruption case, you typically won't see that. You're going to see a lot of paper. You can see a lot of cooperating witnesses. You're going to see some financial transactions. And then all those laid out in kind of a chronological or sequencing order so that the jury can understand the full picture of what occurred.
Mayor Nagin and LaToya Cantrell were elected twice by the people of this parish. Of course, the Eastern District of Louisiana comprises multiple parishes around the area. Is it still difficult to get jurors in a case like this who don't have any sort of preconceived thoughts about the sitting mayor?
Not as difficult as you think. In the Ray Nagin case, obviously, as you pointed out, he was elected twice. Obviously, it's only how many times you can be elected under the city charter. And that was brought up during voir dire, during jury selection. People's voting patterns, those were handled on the side with Judge Berrigan. But we were able to seat, Judge Berrigan was able to seat a jury within one day, and we were doing opening statements soon thereafter.
Wow, that's incredible. Is it any more difficult to get an impartial juror or jury when you're dealing with an elected official?
It is, just because that particular individual is going to have, is going to be known by more people. People will have voted for them. As you pointed out, the Eastern District's multiple parishes. It's 13 parishes altogether. Most of those individuals will know of LaToya Cantrell, and potentially many of them will have a preconceived position or thought about her. But that's not the standard. The standard is, even knowing that, can they put that aside and render a verdict based on the evidence and the witnesses that are presented? And once an individual honestly says, yes, I can do that, that's all that needs to be met. So it's not just knowing of that particular individual.
Now, what kind of time is going to be required of these prosecutors to conduct this trial? I mean, you're in private practice now, correct?
Correct.
Are you spending more time at home these days? I mean, these guys are going to have a lot of long days coming up, correct?
They are. It just depends on when the trial is set. There's going to be, an initial stage of discovery that's going to be produced, maybe some pretrial litigation regarding the discovery, potentially before the magistrate and or the district judge. From there, there'll be somewhat of a lull where the defense attorneys are reviewing that discovery. There'll be some pretrial cutoffs for motion practice. Once those motions are filed, then it will start to ramp up. And then as you get closer to trial, 90 days beforehand, 120 days, witnesses will be subpoenaed for trial, hotel, travel, lodging, everything from there. So it'll be somewhat of a lull in the middle and then ramp up towards the end.
What's your take on what's been going on with the U.S. Justice Department and some of the changes? Should we be confident these same two assistant U.S. attorneys will be prosecuting this case, or is the Justice Department such that we may see some shakeups?
I would expect that the team that you just saw walk out will be the team that goes to trial with that. You may have addition or deletion of one or two, which is, common. But for the most part in the field, most U.S. attorneys' offices remained intact. There's always going to be turnover from administration to administration. But as far as these types of cases, those people that indicted it, you would expect them to be the ones that tried as well.
can you shed any light for us as to how that team will work?